See, we are going to start with this topic today, services under the union and the state. Services under the union and the state. This is a part of part 14 of our constitution. This is the part of part 14 of our constitution. Part 14 of the constitution deals with two basic aspects of this this idea, that is removal, dismissal and reduction in rank. So when we look at part 14 of the constitution, part 14 of the constitution basically it provides for these two aspects. What are those two aspects? First, it talks about something called as disciplinary actions, that is removal, dismissal and reduction in rank of the civil servants. And second, it talks about creation of public service commissions. Creation of public service commissions, and obviously who are to be appointed to such public service commissions, etc., etc. Clear? So if we if we look at part 14 of the constitution, that is article 308 to article 323 of the constitution, these are the two basic ideas that are present there. Let's first deal with this, that is the disciplinary proceedings or the procedure to remove, dismiss and reduce rank of a civil servant. In this context, first thing, let's understand what is the difference between the term removal and dismissal. So what is meant by removal and how is it different from dismissal? The term removal means when an individual is removed from public service, he can further at any given later on he can be employed under the government. If he is removed from service, he is still eligible. Suppose he applies for some other service and he gets into some other service, he can still be a member of that service. When an individual is dismissed from service, he can never further be employed under the government of the state or government of India. So what is removal? Removal simply means that if an individual who is he is removed from service, he is eligible for further employment under the government, but once an individual is dismissed from service, he is disqualified for any further employment. This is the meaning of the term removal and dismissal. Now, when we talk about this provision, removal, dismissal and reduction in rank, there are two important articles that we need to see here, which are Article 310 of the Constitution and Article 311 of the Constitution. Article 310 of the Constitution and Article 311 of the Constitution. Article 310 of the Constitution says that an individual who is appointed in the service of the government, that is under the union government or under the state government, he will work on the pleasure of the president or the governor, as the case may be. Which means if you are employed under the state government, in that case you work under the pleasure of the governor. And if you are employed under the union government, so whether you are a member of All India Services or if you are a member of Central Services, you work under the pleasure of the president. So Article 310 of the Constitution talks about the pleasure principle for civil servants. Now, not every individual who is employed under the union or under the state, not everyone works under pleasure. I am talking about civil servants, which means there are certain offices that are exempted from pleasure principle as well, like the judiciary or the judicial members that are there. They do not work under the pleasure of the governor or the pleasure of the president. They do not work under the pleasure principle, which means that when the governor is to remove or when the president is to remove any member who is not working under the pleasure of the concerned office, there is a procedure that has been prescribed within the Constitution itself. The manner of removal of the individual, the grounds of removal of the individual, it has already been mentioned in the Constitution itself. Like when we talk about the judges of the High Court and the Supreme Court, the judges of the High Court and the Supreme Court can be removed upon a resolution passed by the Parliament by a special majority. And if the resolution is signed or the order of removal is signed by the president in the same session in which the resolution has been passed by the parliament, then the individual can be removed. This is what the Constitution says. It also mentions what is the ground for removal. What is the ground for removal? It says it is incapacity or misbehavior. Incapacity or misbehavior. So the Constitution, Article 124 of the Constitution, or for that matter, if you see Article 213, 217 of the Constitution, it very explicitly deals with the fact that the judges are not working under the pleasure of the president or the pleasure of the governor. Clear? So all the members who are employed by the central or the center or the state, they automatically do not work on the pleasure of the president or the governor. But those individuals who are working in civil capacity, some of them work under the pleasure of the president or the governor. So when we talk about removal, of these civil servants, in that case because they are working on the pleasure principle, so they are to be removed accordingly. Clear? Similarly, I did mention an idea called as Comptroller and Auditor General, and I did say that Comptroller and Auditor General also does not work on the pleasure of the president. Nature of office is such. So there are number of offices that are there under the Constitution itself, those who are employed by the center or are employed by the state, but they do not work on the pleasure principle. Some of the civil servants, they work on the pleasure principle. So we are talking about those individuals who are working on the pleasure principle. So you will find Article 310 of the Constitution talks about this very idea. Similarly, Article 310 of the Constitution further also mentions about a right that a civil servant will have. About a right that a civil servant will have when he is under the said disciplinary action, when the disciplinary action is being taken against that particular civil servant. What is the right that has been mentioned? Article 310 of the Constitution says that he will be heard. Also, the principle of natural justice dictates this idea. No one shall be punished unheard. Audi alteram partem. So the principle of natural justice this dictates that no one will be punished unheard. No one will be punished unheard. And that is the reason why Article 310 of the Constitution provides a right to every civil servant that when they are being removed from service or dismissed from service or reduced in rank, they will be given the opportunity to be heard. The second right is mentioned under Article 311 of the Constitution, which says that a civil servant will not be removed from service or dismissed from service or reduced in rank by an authority subordinate to the appointing authority. By an authority subordinate to the appointing authority, which means that if the governor has appointed the civil servant, so any authority which is either equal to the office of governor or above the office of the governor, only that authority has the right to dismiss, remove or reduce the rank of that particular civil servant. Similarly, when we talk about the members of central services, the members of central services are to be removed only by the president. Why? Because they are appointed by the president, and we have already seen as a part of our discussion under Article 53 of the Constitution that the president is the chief executive authority. No office, no executive office is above the office of the president. So, the members of All India Services and the members of Central Services appointed by the President, those members who are appointed by the President, they can only be removed by the President by no authority other than the President, because no one is above the President. Clear? So when we look at this particular idea, when we talk about this particular idea, that is disciplinary actions, it is Article 310 and Article 311 of the Constitution which deals with what are the disciplinary actions that can be taken against a civil servant. And it basically talks about two ideas. First of all, what are the rights that are mentioned? Now, what are the rights that are mentioned? Like the rights that are mentioned is that an individual will have the right to be heard. So, he will not be dismissed from service or removed from service or reduced in rank without being given the appropriate opportunity to be heard. Second of all, it also says that an individual who is to be removed from service or dismissed from service or reduced in rank will not be, any kind of disciplinary action will not be taken up against him by an authority that is subordinate to the appointing authority. Subordinate to the appointing authority. This is the right that has been mentioned here. And this right is derived. It's not that it is explicitly mentioned as a right. It is not named as a right of a civil servant. This right is derived with the procedure that has been mentioned under Article 310 and 311. It is the procedure. No one will be punished unheard. It is a procedure, and from that procedure, the civil servant is deriving that right to be heard. Similarly, the Article 311 also talks about certain procedural rights that is not subordinate to the appointing authority. Not subordinate to the appointing authority. And the procedure that is mentioned in the Constitution, through that procedure, the individual enjoys what? The individual enjoys that particular right. Clear? Now, when we talk about the rights that are there, initially, before the 42nd Constitutional Amendment Act that was taken up in 1976, this right was given to a civil servant twice. That means the whole procedure was repeated twice. That means as a civil servant, if you have performed an action on which an investigation is initiated, in that case, you were given the right to explain yourself first during the investigation, and second, after the investigation was completed, and then you are given the right to again then you are given the right to do what? Again you are given the right to be heard, that is to explain yourself. The 42nd Constitutional Amendment Act, by the 42nd Constitutional Amendment Act, now the right has been given only in one place. That means during the inquiry that is going on, in that case you will be given the opportunity to be heard. Also, the procedural right that we have as a civil servant, that that is the procedure to be the right to be heard, or for that matter any individual who is subordinate will not remove. This can be waived off. Specifically, if we talk about the right to be heard, in certain cases it can be waived off. What is that case? If a civil servant is held guilty of a criminal offense, if a civil servant is held guilty of a criminal offense, in that case he might not be given the opportunity to be heard. It will be assumed that because the judiciary, there is a process that has been taken up, and in the judicial, in the court, you were allowed that right and you were not able to explain yourself properly, or it was proved, whatever your claims were, it was proved contrary to it, hence you will be deprived of this opportunity. So you cannot ask this opportunity in a criminal offense, when you are held guilty in a criminal offense. Second, if the deciding authority feels that for any particular reason, it may so happen that it is not practical. Now, it is not practical for allowing that particular individual to explain himself, or for that matter, if the president or the governor decides that this is not in the interest of the security of India, in that case you can be deprived of the right to be heard. Clear? So this is when we talk about the first part of it, that is disciplinary actions. Yesterday, when I specifically at the end of the class, I specifically told you to go through Article 308 onwards, that you should go through it, because if you look at these articles, what is Article 308, what is Article 309, so I am not going to go into those articles. It's not that important, though there are some technical aspects that are there, but what is important here is Article 310, Article 311, Article 312 of the Constitution. We have already dealt with it. So Article 310 and Article 311, these two provisions are considered to be most important here. Why? Because it deals with the disciplinary proceedings. The Second Administrative Reforms Commission. The Second Administrative Reforms Commission, which was chaired by Virappa Moily, recommended that both these provisions, Article 310 and Article 311 of the Constitution, should be repealed from the Constitution. According to the ARC, Article 311 of the Constitution gives undue protection to civil servants. It gives undue protection to civil servants. Why? Because in certain cases, because only the president and the governor, specifically when we talk about central services or all India services, because only the president has the right to remove. The president has appointed them, so only the president enjoys the right to remove that particular individual from service. It gives undue protection to the civil servant. There have been number of such cases. One of the very important case here is, I'll give you an example of, I think this happened somewhere in 2006. So there was an IAS couple in the state of MP. There was an income tax raid that happened on their official residence, and 100 crore worth cash was recovered. 100 crore worth cash was recovered, and properties worth thousands of crores was recovered. They are still in service. That is, it has been almost 14 years. It has been almost 14 years, though they are suspended, but they are still in service. They have not yet been removed or dismissed from service. This is what I mean. When I say still in service, this is what I mean. They have not yet been removed or dismissed from service. There was an individual in the state of Bihar, Gautam Goswami. He was, he was one of those civil servants who remained a lot in limelight because when L.K. Advani had organized his Rath Yatra, for Ram Temple, Ram Mandir, etc. When it reached Bihar, it was Gautam Goswami who stopped it. The then Chief Minister, Lalu Prasad Yadav, he actually said that this will not be taken up in Bihar because it might lead to some communal problems. And accordingly, it was Gautam Goswami who stopped it when L.K. Advani, who was about to become the next Deputy Prime Minister of India, when he was taking up that particular Rath Yatra, it was stopped by him. Now, he was accused of mis-embezzlement of funds worth 300 crores, which was given by the center as grant to the state for flood relief. So Bihar, there is a problem with Kosi in Bihar. The river, it tends to frequently change its course, and because of it, almost every year during the monsoon season, there is floods in Bihar. So a relief package worth 300 crores, which was given by the center in the 1990s itself, somewhere around 1990s, and he was accused of mis-embezzlement of funds. He was not removed from service. That means he continued from service, he resigned from service, he joined Sahara group, then he joined the Tata group, he died. Yes, in around 7, 8 or 10 years ago, because he suffered from prostate cancer, he died. But he was never removed from service. Why? Because obviously he was a member of All India Services. In fact, he scored, I think, rank 3 or 4 in UPSC. He was ranked 3 or 4 in UPSC. And he not only did serve, he served after being alleged of that case of corruption. He served, I think, almost 10 years of service. After that, he voluntarily retired from service. He joined a private organization, continued to work in that private organization for 5-7 years. After that, because of the problem that he had, health related, so he resigned from service. He, in fact, 10 years ago, he died. But if you look at the case during that particular period, after 10 years of being alleged of embezzlement of funds, which was more than somewhere around the total money that was embezzled in that very case was 300 crores. It was not a small amount. ठीक है? सोच रहा हूँ क्या होता तो क्या होता. So 300 crores. He embezzled that fund, but he was not removed from service. He was not dismissed from service. Why? Administrative Reforms Commission says that it is because of Article 311 of the Constitution. The procedure that is mentioned under Article 311, which empowers only the central government, or in this case the president. Obviously the president will act on the advice of the central government. So only the president is empowered to remove an individual who is a member of central services or All India Services. And that is the reason why Administrative Reforms Commission has went to an extent wherein it has recommended repealing Article 311. And not always, see, this particular article has another side of the argument as well. The other side of the argument is that when we talk about the office of the president, when we talk about any kind of political determination of whether an individual should be removed or not, there has to be some check on it. Because if you empower, if you empower a political body to remove civil servants, they will use it for their own political advantages. And because of this procedure itself, that the president has the right to remove, and hence because the procedure itself becomes complicated, so there are some civil servants, who do what? There are civil servants who are protected because they do not act in accordance to the political directions that are given. Rather than they do what? Rather than acting as on political directions, they are neutral. When I say political directions, I do not mean that you do not follow the decisions of the Council of Ministers. But there are some decisions which are taken by some political authorities with the motive of not promoting public interest. Rather, the objective is what? The objective is to promote the interest of an individual or a political party. In that cases, in those cases, it is said that it is because of Article 311 of the Constitution that civil servants get some due protection. The civil servants get some due protection. And this argument is also not wrong, because even the story of Gautam Goswami has two aspects. One is wherein it is said that he had actually indulged in corruption and embezzled that fund. The other side of the story was that because he did not agree to his political masters, so he was actually alleged. It was just alleged so that his reputation can be destroyed, and there was no actual embezzlement of funds. So in both these cases, there are two different arguments that are present. But we still continue with Article 311 of the Constitution, which says that only the appointing authority has the right to remove, dismiss or reduce the rank of a civil servant. Clear? This is what is Article 310 and Article 311 of the Constitution, which deals with disciplinary proceedings. It is because of Article 311 of the Constitution that members of All India services, now the All India services that are there, this is a problem for the states. Why? Because once you get into All India services, you are allotted state cadres. There are around 24 state cadres that are there. There are some mixed cadres for the Northeast and for the UTs, etc., etc. There are some mixed cadres that are there. 24 cadres, and you will be allocated one of those cadres. There has been recently some changes in how allocation is to be done, but previously it was based on the rank you get, based on you are going to choose your cadre by filling up your preferences when you do that in your mains examination as well as in your interviews. You are told to, when you are submitting that form, you are told to choose cadres, and you are going to come out with your preferences. So based on that, you are allocated a cadre, a state cadre, and for most of the service that you give in the government, you will be in that particular state. So you are initially, after your training, there is a probationary period. Recently there has been some change in how IAS are trained. So initially it is 90 days. Previously it was that you were directly sent to the state. Now that is not the case. Some 90 days or 100 days of training in the central secretariat, probation in the central secretariat, then you are sent to the allocated state cadres. And there you serve at least 15-20 years. And then it may so happen that you are on central deputation. So you are then transferred from the state to the center. And then after serving a certain time period in the center, again you are shifted back to the state, again you go back to the states. So most of the time in your service, you are basically working under the directions of the state executive, under the state government. But what is the problem? The problem is Article 311. Article 311 says if you are to be removed from service, or dismissed from service or reduced in rank, it will be done by whom? By the president. That is not by a subordinate to the appointing authority, not by an authority that is subordinate to the appointing authority. In this case, the state government, the state executive is subordinate to the appointing authority. That is, the appointing authority is the president. So neither the state executive can remove you from service, neither the state executive can dismiss you from service, neither the state executive can reduce the rank of the civil servant, of the all members of All India service. What does this lead to? This leads to a lot of problems that happens between the members of All India service and the state executive. So there was a case that came up again around 5-8 years ago, Durga Shakti Nagpal case in the state of UP. What happened? Durga Shakti Nagpal, she was an IAS and district collector of one of these districts which has been famous in UP for sand mafia and sand mining that was going on. So she took up certain action against the sand mafia. The then Chief Minister Akhilesh Yadav, he suspended her, because that is what the state government can do, suspend or transfer. So she was suspended from service, and the members of All India service, they went on a leave, because we know they cannot strike. We know that we have already discussed fundamental rights, so they cannot strike. So they did what? They went on a leave. They went on a leave, leading to finally the state government had to do what? The state government had to reinstate that officer. The state government had to reinstate the officer. So because of this continuous leave, there was a time wherein the chief ministers of the state of UP then made a statement saying, सेंटर को अपने ये सारे ऑल इंडिया सर्विस वालों को वापस ले जाना चाहिए, and we will manage by the members of state services. That is a problem. There was also a case recently in Delhi. The chief secretary of Delhi was manhandled by the MLAs of Aam Aadmi Party. So the chief secretary was called to a meeting. When he went to a meeting, he found that there were number of MLAs who were there of the Aam Aadmi Party, including the chief minister of Delhi. And these MLAs, they physically assaulted the chief secretary of Delhi. After he left the meeting, he went to this I think this trauma center in AIIMS or Safdarjung, and there was a medical checkup that was done, and this medical checkup, it proved that he was manhandled, and he registered an FIR against the members of Aam Aadmi Party, some of the MLAs of Aam Aadmi Party, including the chief minister of Delhi. And because obviously he is the chief secretary of Delhi, which means he is the senior most civil servant in Delhi, and because of this, the members of All India services in Delhi, the members of IAS association in Delhi, they went on a leave. And that continued for 7 days. Until the 7 days, because see, the members of All India services, they occupy very key position in administration, whether it is the state or whether it is a UT like Delhi, they occupy very key positions. So if members of All India service or IAS association, they go on a break in a state as huge as UP, which means there is no district collector that is working. There are not just district collector, divisional commissioner, all these individuals who are IAS. So in the state of UP, there may be at least more than 2,000 IAS who would have been employed in the state of UP. So they were all on a break. So you can understand the problem, the administrative problems that it causes. And this is also so done because the members of All India service know that they cannot do anything about it. what they can do is suspend or transfer. But when there is a mass leave, like in Delhi or in UP, there cannot be suspension or transfer. That will not be possible. That is not going to be possible. Sometimes you will see that as soon as a political party, the political party wins elections and comes to power, what they do is they take up mass transfer of IAS and IPS. So in UP, whenever the government changes, the next day in the newspaper you will always find 1100 IAS is transferred. This happens. Why? Because this is what they can only do, because they are occupying key positions. They are occupying key positions, and that is the reason why this happens. Otherwise, if they were not occupying such positions, in that case, why is there a need to transfer them? There will be no such need. But because the states have very limited disciplinary powers against, very limited disciplinary powers against the members of All India Services, that is the reason why there are some problems between the members of All India Services and the state government. Not just between the members of All India Services and the state government, even All India members of All India Services are also sometimes, this service itself is a problem between center-state relations. This is also a problem between center-state relations. Why? Because at any given point of time, a particular officer can be told to go on central deputation. So sometimes the state accuse that अच्छे सारे officers ले जाते हैं, सब बेकार वाले छोड़ देते हैं. They also accuse that sometimes they tend to do what? They tend to take all the good officers to the center and leave us only with those officers which have either not done any exceptional work. This further leads to inefficiency in administration. Sometimes members of All India Services are accused to be nothing but agents of center, and through members of All India Services, the center tries to exercise control over the state government. Why? Because the state government, these individuals are not just though they are working in the state, but they are not just implementing policies and programs that are made by the state government. They are also implementing policies and programs that are made by central government, called as centrally sponsored schemes. And the manner in which they implement that, that also itself, that is one of the reasons why they are also accused that, this whole idea of an All India Service that is there, that is in itself a problem. Interestingly, if you look at the initial draft of the constitution, the first draft of the constitution, it did not give constitutional status to the members of All India Service. There was no such constitutional status that was given to members of All India Service, because it was considered to be what? It was considered to be a legacy of the Britishers, because this, what we see as All India Service today, what we see as All India Service today, this was also present during the British period. So IAS is not, this office that is there, this service of an IAS, it was during the British period, it was called as ICS, Indian Civil Services. Similarly, IPS was then called as Indian Police. So both of these services were in existence. So because the Constituent Assembly felt that this is nothing, the members of All India Service or this whole service itself, All India Services itself, it is nothing but a legacy of the past, or a burden of the past. So the initial draft of the constitution did what? The initial draft of the constitution did not include it as a constitutional provision. Later on, Sardar Vallabhbhai Patel gave a very passionate speech in the Constituent Assembly. He went to an extent wherein he said that the unity of India is dependent upon the members of All India Service. They will tomorrow act as the steel frame of the country in the development of the country, and if we give up this particular office today, it is very likely to lead to disintegration of India. It was because of Sardar Vallabhbhai Patel that All India Service was given constitutional status, and that is the reason why he was called as the father of all India services. He is called as father of all India services. But ऐसा कुछ exceptional देखने मिला नहीं है from members of All India Service. But he was a visionary, maybe not now, tomorrow कभी होगा, लेकिन ऐसा कुछ constitutionally speaking this is the whole provision. ठीक है. The members of All India Service, I have explained what is Article 310, I have explained what is Article 311, we know what is Article 312. We have also seen what are the procedural rights that are enjoyed because of Article 310 and Article 311 of the Constitution. We have also seen that what is the problem here between center and state and how All India Services becomes a problem between center and state. And we have also seen Article 311 and its consequences, which has, that is the reason why Administrative Reforms Commission, the second Administrative Reforms Commission, has recommended for repealing of Article 310 and Article 311. Clear? Write this. A person working in the civil capacity under the union or the state works under the pleasure of the president or the governor as the case may be. The doctrine of pleasure means that such a person can be removed from service by the president or the governor without assigning any reason. The doctrine of pleasure under the Constitution has the exception that judges of the Supreme Court, High Court, the Comptroller and Auditor General, the Chief Election Commissioner, can be removed from service only on the grounds and in accordance to the procedure as has been provided under the Constitution. A civil servant, when he is subjected to any penal consequences, does not have any right of being compensated, does not have any right to be compensated by the government, but there are two exceptions to this rule. First, when the service of a person which are taken by the government on the account of technical expertise of the person under any contract for a particular period of time, will be compensated if he is removed from service before the end of the contract period. Second, such a person is also to be compensated if the post is dissolved before the completion of the contract. Next paragraph. But such a person is not to be compensated if he is removed from service on grounds of misconduct. Next, give a subheading, right? Rights of civil servant under the Constitution. The Constitution under Article 311 provides procedural rights to the civil servant before they are subjected to any penal consequences in the form of dismissal, removal, or reduction in rank. These rights are first, a civil servant cannot be subjected to any such action by an authority which is subordinate to the appointing authority. And second, the civil servant has the right to be heard at the stage of inquiry before any penal recommendation is made. Next paragraph. Before the 42nd Constitutional Amendment Act, the right to be heard was available at two stages. First, at the stage of inquiry, and second, before the inquiry authority took the decision of removing or dismissing the civil servant. The second stage stands deleted. Next paragraph. The procedural rights under Article 311 has the following exceptions. First, if a civil servant will not be heard if he is to be removed on the grounds of conviction in a criminal offense. Second, if the deciding authority for any particular reason provides in writing that it is not reasonably practical to hold such an inquiry, and third, if the president or the governor provides that it is not in the interest of security of India to hold such an inquiry. The next part of our discussion under part 14 is public service commissions. Article 311. No, procedural rights have been mentioned under Article 311. Public Service Commission. See, when we talk about Public Service Commission, there are basically three types of Public Service Commissions: Union Public Service Commission, Joint Public Service Commission, and State Public Service Commission. The members of Union Public Service Commission and Joint Public Service Commission are appointed by the President, whereas the members of the State Public Service Commission are appointed by the Governor. They are appointed by the Governor. A member of Public Service Commission, Union Public Service Commission, has a tenure of 6 years or 65 years of age, whichever is earlier. A member of Joint Public Service Commission and State Public Service Commission, they have a tenure of 6 years or 62 years of age, whichever is earlier. Clear? So appointment is done by the concerned authority, and the term of service has also been mentioned in the Constitution. If you look at this Public Service Commission that are there, these Public Service Commission, the Constitution does not prescribe any kind of limit to the membership of the Public Service Commission. So it does not say it will have 10 members, 5 members. It only says that at least the condition that is provided in the Constitution is at least half of the members of Public Service Commission, they will have administrative experience, which means they will have at least 10 years of experience under the government of India or the government of the state. Under the government of India or under the government of the state. Which means if you look at this provision that is there, specifically, if you go to that particular provision, that is at least half of the members should have 10 years of experience under the government of India or the government of state. This provision is something that questions the effectiveness of public service commissions, because it only prescribes this qualification for 50% of the members. However, the constitution does not detail what qualifications the other 50 members are going to have. So the constitution is of the opinion that an individual will have 6 years of tenure, and whether 65 years of age or 62 years of age, depending upon the membership to which commission, its constitution simply says that at least in terms of membership, at least 50% of the members should have 10 years of experience under the government. But what should be the qualification for the other 50 members, other 50% of the members, is not laid down by the constitution, which means any individual with or without proper qualifications can be appointed to such offices. Why? Because the constitution does not limit the executive powers of the government in this particular context. It does not limit the executive powers of the government. And this is the reason why you will find, though this does not happen in Union Public Service Commission, it does not happen in the Union Public Service Commission because the appointments to UPSC, it gets widely published. Who are the members who are being appointed to as members in the UPSC? It gets widely published. But that is not the case when it comes to the State Public Service Commission. And that is the reason why if you look at the membership of the State Public Service Commission, sometimes it is very questionable. Example, State of Haryana. In the year 2013, in the state of Haryana, 2 members of the Public Service Commission that were there, they were convicted of murder. They were convicted of murder. See, it was not that, because they were convicted of murder. So obviously the government, no one can predict, okay, what will happen in the future. But that particular case that was registered, that was already registered against those individuals since 2009. They were appointed to this commission in 2011, and in 2013 they were convicted of such an offense. The question is, why was there a need to appoint such individuals with such a kind of history or such a kind of background to such public service commissions? There was no need to do that. Why? Because they were politicians. They were not civil servants. They were politicians. They were involved. They were members of the Congress party. They were members of the Congress party, and then that was the government that was there in the state of Haryana, so they were appointed. And this is only an example. It's not just about the Congress party. It is being done, it will be done, it can be misused by any political party. Why? Because the constitution does not prescribe qualification for 50% of the members. It only prescribes this qualification for only the 50% of the members. The remaining 50% of the members, any individual can be appointed to this. Now, under the constitution, what is the job or what is the role that has been conceived of public service commissions? What is the role that has been conceived of? The role that has been conceived of public service commission is to act as a body it would guard or protect the merit system in India. This is the role that has been conceived of. This is the role that has been conceived of. But if you allow for such provisions, If you allow for such provisions such as 50% of the members belonging to, even if it belongs to a political party, now that is definitely going to have political influence in the recruitment process. It is going to lead to political influence in the recruitment process. And that is the reason why you will find when it comes to these state public service commissions, there are so many problems that are there with these state public service commissions. In UP, in the year 2000, there is no need to laugh. UP is the most populated state and frequently in news. So I tend to read that. In the state of UP, in a public service commission exam that was held, it was alleged that around 300 odd members who were selected in this through this examination, 280 of them belonged specifically to a particular caste. They specifically belonged to a particular caste. In the state of Jharkhand, the third public service commission examination that was held, out of the 200 odd members that were selected from that particular examination, 23 of them are right now in jail. 23 of them. Why? Because it was alleged that they had somehow influenced the process, and this led to a judicial inquiry, and it was found that they had actually bribed the chief minister. So that this was not included in the inquiry, but it was said that the whole process of recruitment in that particular examination was conducted not by the concerned public service commission. It was being directed by the political class. And some individuals, these 23 ones that we are talking about, their mains script was actually released, and it was found that some of them had scored 0, but they still got into the service. Why? See, it's not, the question is why. Because when you look at the membership of this, the public service commission that is there, and the kind of influence that the political parties or the executive may enjoy on this particular body, and that is the reason why. That is the reason why such, you tend to frequently hear about such things. You will find that public service commission, the state public service commissions that are there, they have become inefficient. Except for some of the states, they have become inefficient. And we cannot deny that in 100% of the states, there are cases of corruption that are there. So the constitution conceives them of what? The constitution conceives them as the guardian of merit system. But because of some provisions that are there in the constitution, the manner in which it has been mentioned in the constitution, they are not necessarily acting as the guardian of merit system. They are not necessarily acting as the guardian of merit system. Though we claim merit system is there, but that is not, that may not necessarily be the case. There are political appointees to these commissions. There are frequent delays because of corruption, because of inefficiency in these organizations. Clear? This is what this is the, when we talk about the membership of public service commissions. Clear? So you can just write this, public who is appointed. If you have written, then I'll move for you. Have you written this? Right, just write this down. 10 years of service under the government. 10 years of If you have written this, give a subheading removal. Removal. Removal of members of Public Service Commission. Removal of members of Public Service Commission. So how can the seats that are there in these Public Service Commission, how can they fall vacant? Obviously there can be two reasons. First is if a member resigns, and second is if he is removed from service. So in terms of removal, always remember that there can be resignation also. So the first point that you write here is through resignation. Though in this case he is not being removed from service, he is resigning from service. Resignation. Second point. A member of Public Service Commission can be removed on the following grounds. On the following grounds. First, on the grounds of being adjudged. On the grounds of being adjudged and insolvent. Second, if he engages in any paid employment, outside the service. Third, if he is in the opinion of the president of infirm in mind or body. And fourth, on the recommendation of the Supreme Court, that the person is guilty of misconduct, underline misconduct. Also underlined recommendation of the Supreme Court. Misconduct under the Constitution means the following. First, if the member engages in any contract, with the government of India or the government of state. Second, if the person has an interest in any profit out of this contract. Clear? Misconduct has been constitutionally defined. See, if we talk about any other offices, like if we talk about Public Service Commission, leave aside Public Service Commission, and if you look at any other office, like if we talk about the judges of the Supreme Court, if we talk about the Comptroller and Auditor General, all these offices that are there, the Constitution only mentions the grounds. That is, what is the ground? It mentions that the ground is misconduct, incapacity or misbehavior. This is the ground that has been mentioned for them. But how is the grounds? How is this misbehavior or incapacity decided? It is decided by it is politically decided. You will find that judges that are there in case of judges, it is politically defined. It is both of the houses passes a resolution, and accordingly there is a process that is followed. Even when it comes to other members like Comptroller and Auditor General, you will find that the Comptroller and what is the process, it is mentioned in the Constitution itself. For members of Public Service Commission, not only the process is mentioned, that is the Supreme Court will on the recommendation will do this. Now any matter will be referred to the Supreme Court. Supreme Court would investigate it and then will recommend to the President or the Governor, as the case may be. In this case, not only the Supreme Court conducts this exercise of seeing whether misconduct has happened or not, what is misconduct has also been defined. It is if the individual indulges in any contract with the Government of India or Government of any state and has some any kind of interest in that particular contract, that will amount to misconduct. Why? Because this office has to be independent. Merit system, so it has to be independent. If the office is not independent, how can we say the office will not be independent? If I indulge with a contract with the government, with the executive, obviously I have some economic interest or some other interest. If that is the case, how can it be considered that this individual in this capacity will act completely neutral? That may not necessarily be the case. It may so happen that I have been given such a contract. In that contract, the condition is that if I follow the directions of the executive, and that is the reason why this will be construed as misconduct, and accordingly the Supreme Court will recommend the concerned authority to remove the individual. Clear? So what is the ground? It has specifically been mentioned. See, till now, when we were talking about the members of we are talking about the members of the parliament, the ground was what? The ground was office of profit. Only office of profit. Those individuals who are members of legislature or are parliamentarians, they can indulge in any private contract. It does not matter. They should not hold any office of profit. But in this case, members of UPSC or for that matter Public Service Commissions, they not only cannot hold any other any office under any private office, they can also not hold any office under the government except for cannot enter into any contract with the government except for discharging their duties as the members of Public Service Commission. Except for this, they cannot do anything. Why? Because if they indulge in any private contract, they can be removed by the President. If they indulge in any contract under the government, the Supreme Court can recommend the President to remove these individual. This is what is removal. Article 317 of the Constitution talks about the removal of members of Public Service Commission. Next, independence of Public Service Commission. Independence of Public Service Commission, because we have been stressing on this idea that this is a guardian of merit system, which means we have to ensure that this body is completely an independent body. So, what are the steps to ensure independence of Public Service Commission? First, the members of Public Service Commission can be removed from service only on the grounds provided under the Constitution. Only on the grounds provided under the Constitution. So executive cannot at any given point of time remove them. They can be removed only on the ground that has been mentioned in the Constitution. Except for that, they cannot be removed. Second, the conditions of service of the members, cannot be altered to their disadvantage during the term of service It cannot be altered to their disadvantage. We have already dealt with this idea previously also. That means you can increase the conditions. That means you can increase the salary, pension, etc. But you cannot decrease them. It cannot be altered to their disadvantage. So any conditions of service, terms and conditions that have already been previously decided, it cannot be altered to their disadvantage. Provided, when can it be done? Financial emergency, not emergency, financial emergency. Next, the expenditures of the Public Service Commission, is charged upon the Consolidated Fund of India. Now, what is the meaning of charged expenditure? We know that. What does it mean? Cannot be voted upon. It can be debated, discussed, but it cannot be voted upon by the Parliament. So, once you make it a charged expenditure, which means you are completely ensuring that there is no influence of the executive, because it will be presented as a money bill. And if it is presented as a money bill, it means Lok Sabha, Rajya Sabha does not have powers. Lok Sabha enjoys overriding powers, which means if the executive wants, they can alter the expenditure. So once it is presented as a charged expenditure, it means it cannot be altered. Clear? Next, the members of Public Service Commission, are subject to limitations. Subjected to limitations with regards to future employment. With the government. In brackets, write Article 319. So members of Public Service Commission that are there, these members can be under the service of the government only with certain conditions. There are certain conditions that are imposed. What are those conditions? The chairman of the UPSC cannot hold any office under the government of India or government of state. Once he retires as the chairman of UPSC, no, he cannot hold any office under the government of India or government of state. Second, a member of UPSC can only become the chairman of UPSC or the chairman of any state public service commission. Third, the chairman of state public service commission can become the member of UPSC, or for that matter the chairman of UPSC or the chairman of any other state public service commission. Otherwise he is not qualified to hold any other office. And a member of state public service commission can either be chairman of state public service commission, chairman of some other state public service commission, or member of UPSC or chairman of UPSC. Except for them, they cannot hold any office under the government. So only this is the office that they can hold. Except for this, they are not qualified. They are not qualified to be to hold any office under the government of India or the government of any state. Clear? So they are subjected to these conditions. Write this down. First, the chairperson of UPSC, no, the first point within this, Article 319, first point there. The chairperson of UPSC cannot be under the service of the union or state, after retirement. Second, the chairperson of state public service commission can only be appointed as a member or chairperson of UPSC or as the chairperson of another chairperson of another State Public Service Commission. Third, a member of UPSC can be reappointed as chairperson of UPSC or State Public Service Commission, SPSC. And fourth, a member of State Public Service Commission, SPSC, can only be reappointed as chairperson of SPSC or UPSC or member of UPSC. This is the conditions that have been mentioned under Article 319. So if next, this is a topic that I would like you to go through. It's very factual. Functions of Public Service Commission. That is Article 320 of the Constitution. You have to learn this. What are the functions that are there? See, when it comes to independence of this office, there is again a problem here. There are two things that we see here. First of all, the office of the governor has not been considered as an employment under the union or state. So they can be appointed as the governor, which should not be done. But this reason is that, if you look at the office of governor, how it has been conceptualized in India, it is considered that, if you do not allow civil servants or individuals to be appointed in that office, so remaining it will always be politicians. That the politician is appointed to that particular office because only they are not barred. Otherwise, everyone will be barred to any such office. So that is the reason why the court feels that this office should not be considered. But the problem is the manner in which such appointments are done. Sometimes it is done just purely with political motivations, and that should not be the case. Like I did give you an example, a previous member of UPSC. He was appointed. He was previously he was the chairman of not chairman. He was a member of UPSC, and then he was appointed as the governor of a state in Northeast. So he was the one who is the chairman of the board. The board in which I appeared for interview. So he asked me a question कि ये बताओ जब कृष्ण शांति दूत बनकर गए थे दुर्योधन के पास, तो उन्होंने 5 गांव मांगा था पांडव के लिए. ठीक है, he asked for 5 villages. उन 5 गांव का नाम बताओ. Yes, he asked me this particular question and I had no answer. Obviously, क्योंकि उस समय, अब ठीक है, अब तो बता भी सकता हूँ, उस समय तो गांव नहीं पड़ता. So he asked me this particular question. So I remember his name. I will remember his name forever. So this is a question that he asked. This is a problem. See, I will not say that was the question that decided the interview or something like that. He, for any reasons why he was, he asked that question. But the thing is that later on, after his retirement, he was appointed as the governor. And such appointments that are done, such appointments can always be considered. Now, such appointments can be considered political appointments, and that is not the only problem. We see that some members of UPSC who retire, after that they tend to engage in private employments. Now, within this, this industry itself, they actually they engage themselves with economic benefits. That should not be the case. That should not be the case. It's not that you cannot guide aspirants who are taking these examinations. You should do that with respect to what requirements you feel the organization should have, but it should not be done purely with economic motives. But the thing is that there cannot be a legal mechanism for this. This is dependent upon the ethics and morality of an individual. You cannot come up with that, you cannot stop an individual to take up employment once he retires, private employment once he retires as a member of such organizations. But what kind of employment, that is something that should be seen. But again, it is not something that can be decided by a law or by the constitution. It is dependent upon personal ethics and morality of an individual. Personal ethics and morality of an individual. So that is something that needs to be seen. With this, we complete our discussion on part 14 of the constitution that deals with these two ideas, that is Public Service Commission and central services. Next, we come to part 15 of the constitution, which deals with elections. Part 15 of the constitution, elections. See, again, like part 14, even part 15 of the constitution deals with two basic ideas. What are those? Organization of elections and election commission. It deals with organization of elections or the election commission. See, if you look at the constitution has these two provisions, or the objective of part 15 of the constitution is to ensure free and fair elections. To ensure free and fair elections, and so that the democracy of the country functions well, so that there is smooth transition of power. If it is, we have given this idea of elections a constitutional status. Now, we have given it a constitutional status, and accordingly what we have done is we have included two aspects of elections as a part of part 15, one dealing with organization of elections and the other dealing with election commission. Before we get into election commission, let's first discuss this idea, that is organization of elections. Organization of elections. First article here is Article 326 of the Constitution. Article 326 of the Constitution. What is Article 326? Yes, universal adult franchise. So you can first write this. It extends universal adult franchise to all citizens of India. To all citizens of India. Underline this, universal adult franchise. Now, what is the meaning of universal here? Universal means without discrimination. The term universal means without discrimination on the grounds of sex, caste, religion, region, etc. Universal means universal. There is no discrimination. Religion, race, caste, sex, place of birth, these are not the grounds for discrimination. Clear? And that is the reason you will find that in India, any individual can become a part of electoral roll of any state or any region, barring some provisions that are there, like, obviously I can, till very recently I could not go and vote in the state of Jammu and Kashmir. Now that is also allowed. Similarly, when it comes to some northeastern states, because of some Schedule 6 and Schedule 5 of the Constitution, there are some constraints. Otherwise you can at any point, if suppose tomorrow you decide to live in whichever state, so where you are born, it does not matter. Whichever state you want or whichever UT you want, you can actually be the member of electoral roll of that particular constituency. So there is no discrimination, absolute no discrimination that is shown. The term adult, here the term adult after the 61st constitutional amendment, it means any individual who has attained the age of 18 years. Any individual who has attained the age of 18 years. This is after the 61st constitutional amendment. After the 61st Constitutional Amendment Act, which was taken up in 1988, now this means any individual who has attained the age of 18 years. Now comes the term franchise. What does this mean? This means the right to vote. Universal adult right to vote. So everyone, without discrimination, any individual who has attained the age of 18 gets the right to vote. What is the meaning of right to vote? What is the meaning of the term when we say the right to vote? What is the meaning of this right? The right to elect an individual, to express. The right to elect an individual. Do you agree with this? इतना आसान होता तो मैं पूछता नहीं. The right to vote, when you say the right to elect, the right to elect is only a part of what we conceive as right to vote. When we say right to vote includes, first, right to cast a ballot. When you say right to elect, it means you only have the right to cast a ballot. Now, right to cast a ballot, that means I can cast my ballot. 8th of February, elections in Delhi. So when I say I will enjoy the right to vote there, what is the right that I have? Suppose I am a voter in Delhi. What is the right that I have? First of all, I have the right to cast a ballot. So on 8th of February, I will have the right to go to the concerned polling booth and I will cast my ballot. Right to vote also means right to contest elections. It means not only do I have the right to cast my ballot, I also have the right to contest elections. Okay? So as a voter here, I might contest elections also. Okay? So if some political party gives me ticket, so I'll contest. I can contest independent also. कम से कम मेरा वोट तो मिलेगा मुझे. Contest elections. But it also includes what? It also includes the right to subscribe nomination of a candidate. Right to subscribe a nomination of a candidate. Right to subscribe the nomination of a candidate. This is also what it means. Now, what is subscription of nomination? What is this? See, any individual, like I said, I might contest elections from a political party or for that matter independently. So, in the electoral mechanism that we have, sources of the of the country, like if we talk about EVM itself. So all those who are contesting elections, their name should be included in the EVM. Their name will be included in the EVM. There will also be what? There will also be a symbol that will be given to every individual. All these things are taken up. So there are some checks that are created. As I said, what did I say? I will at least get my vote. That is not what will happen. Why? Because when I am filing for my nomination, in that case, every individual has to present a minimum number of voters from that constituency who subscribes the nomination of that individual. If the individual does not belong to a recognized political party. If the individual belongs to a recognized political party, the minimum number of subscriptions that are there, it is very limited, 1 or 2 or something like this. But when an individual is contesting from a political party which is not recognized, so he will have to present 25, 50 voters, or at least what you can say, EPIC number. Do you know what is EPIC number? Every voter card that is there, you will find there is an EPIC number there, and that number is to be, that number is presented. When I say that, when I present that number, it means I am subscribing, or some individual is subscribing my nomination in that particular constituency. So as a voter, I also have the right to subscribe the nomination of a individual in the constituency. Clear? This is what is meant by right to vote. This is what is meant by right to vote. If you go in accordance to the Supreme Court's decision, the Supreme Court has also accepted this idea. The right to vote that is there, it also includes the right to reject. The right to vote also includes the right to reject, and that is the reason why there is something called as nota that is present in when we vote. None of the above. It is an expression of right to reject. It is an expression of right to reject. Legally, right to vote means these three things. But if you see the what you can say, the decisions of the court. So in the decisions of the court, since the year, I think it was 2008 or 9, somewhere around this, there was a decision of the Supreme Court. There is a organization called as ADR, Association of Democratic Reforms. That Association of Democratic Reforms filed a PIL in the Supreme Court, and in the PIL they said that right to vote that has been guaranteed to us by our constitution, it does not just mean right to elect an individual, it should also provide us the right to reject. Because if it is providing us only with the right to elect, it simply means that I am being forced to choose an individual despite the fact that I would not like to vote for anyone, any of them. The court agreed to this decision and directed the Election Commission to provide for this nota that is there, this option that is there. None of the above option. It was provided with this particular decision of the court. Clear? So when we say Article 326 of the Constitution gives us universal adult franchise. Now we know what is meant by universal. It means no discrimination. We also know what is meant by adult. After the 61st Constitutional Amendment Act, it means an individual who has attained the age of 18 years. And franchise means right to vote, which includes these legal ideas: right to cast a ballot, right to contest election, right to subscribe for nomination of a candidate. Clear? Supreme Court also includes the idea of right to reject. Right to reject. Someone said right to vote is a form of expression. No, someone said right to vote is a form of expression. You are absolutely correct. Right to vote, yes, it is a form of an expression. It was something that was, the Supreme Court has interpreted this idea in this manner as well. The Supreme Court says that yes, it is the right, the right to vote that we have, it is a manner of expression. Because right to expression is already a part of our fundamental right, Supreme Court, talking about right to vote, correlating the idea of right to vote with the right to expression, right to freedom of expression, the Supreme Court went to an extent wherein it directed that this right to expression means right to an informed expression. And because this means right to an informed expression, hence it directed all the political parties, it directed the Election Commission that any individual who is contesting elections, when filing his nomination or her nomination papers, will also have to file an affidavit which would detail all the necessary information about that individual, so that when an elector is voting for that individual, he is properly informed whom he is actually choosing as his representatives. And that is the reason why you find that whenever an individual files for his nomination paper, the individual has to file an affidavit also. So the affidavit would include all the ideas, that what are his assets, what are his liabilities, what are the education, what is the education qualification that he holds. It will also include ideas such as if there are any criminal cases that are registered against that individual, what are those criminal cases, what is the development with respect to those criminal cases. All these things are mentioned. All these things are mentioned in the affidavit. Why? Because when a voter is voting for that candidate, he should understand that whom he is actually voting for. It was done on the Supreme Court's direction. There is no law. Political parties, why will they say this? Why will they disclose what are their assets? Why will they disclose what are their assets? Why will they want to not just assets of those individuals? It is also, they have to also disclose the assets of their dependents, which means if what is the asset in the name of the spouse, or if there is an asset in the name of their children, they will have to disclose all of it. So I'll come to know, okay, he claims that the farmer leader and he has assets worth 500 crores. कहाँ से आया? तो आप why are you claiming you are आप claim कर रहे हो गरीब के बेटे हो 500 करोड़ का asset है आपके पास. ऐसी गरीबी तो मुझे भी चाहिए. I will not vote for that particular individual. Why? So that when we express ourselves, when we make that particular choice, we make an informed choice. Clear? This is what is meant by this idea of right to vote under Article 326. Next. Article 325. Article 320. It provides for the preparation of a single electoral roll, ROLL, not ROLE, ROLL, for each territorial constituency for each territorial constituency. Each territorial constituency. Underline this: single electoral roll. What is the motive of providing for a single electoral roll? Yes? Brotherhood. Okay. Anything that you can add here? Definitely you are correct when you say fraternity. The idea of single electoral roll promotes the idea of fraternity which we have discussed in the preamble. Yes. Anything that you can elaborate upon this? It's absolutely correct. How can you elaborate upon it? One particular country, but you are voting, this means you are citizen of that particular country.
But it may create a divide, like if a state...
Can you give me an example? You should read your history properly. Communal electorate is the example. Why did we opt for a single electoral roll? What is the motive? Why is it that it is explicitly mentioned in our constitution? The objective is that it is Article 325 of the Constitution which bans communal electorate system in India. The Constitution, any kind of, any kind of mechanism to introduce communal electorate in India will be considered unconstitutional. Why? Because the Constitution provides for single electoral roll, not multiple, not on the basis of religion, not on the basis of race, not on the basis of caste, not on the basis of gender. No such division can be made. Communal, when I say it bans communal electorate, what does that mean? It means yes, because we have a certain historical past of, because of this. What happened in 1909, Minto Morley reforms. It introduced communal electorate system in India. Similarly, 1919, Montagu-Chelmsford reform. What does it do? It extends communal electorate to the Sikhs. Initially to 1909, given to Muslims. In 1919, it was extended to Sikhs. What is this? This is on the basis of religion. But when Article 325, see, Article 325 could also have mentioned that it bans communal electorate system directly. But that would mean what? Discrimination could be done, or different role could be prepared on other grounds. Not on the grounds of religion, but maybe on the grounds of gender. See, today we do not conceive that gender could be a reason wherein this divides the society. It may so happen now after 100 years, not today, but it may so happen after 50 years, 100 years. So that could lead to the kind of division in the society. Article 325 is an example of the far-sightedness of the Constituent Assembly, that they were able to conceive this, that it may so happen that tomorrow this will, if we do not ban this, it will become a valid reason for discrimination, or valid reason, it would defeat the very idea of democracy. Tomorrow if we start with a different electoral role, it defeats the very idea of democracy. Why? Because then not everyone will be allowed to vote. All these provisions which were there in the communal electorate system. So Article 325 is an example of the far-sightedness of our Constituent Assembly. It was an example of far-sightedness of our Constituent Assembly. If this would not have been the case, India may dual electoral roll system नहीं होता. Every region, every caste, every community, every gender would have been divided into different electoral system. It is because of Article 325 of the Constitution. Clear? Write down. In this itself, it prohibits the preparation of electoral roll. It prohibits the preparation of electoral roll based on religion, race, caste, sex, or any of them. It bans communal electorate system in the country. Communal electorate system in the country. It also means all citizens who have attained the age of 18 years, and who are not otherwise disqualified, have the right to get their names, included in the electoral roll. Next, Article 327. So we are talking about organization of elections. So all these ideas that we are discussing, it is the manner, these are the principles that are used for organizing the elections. 327. See, gender is more of a social idea. Sex is more biological. Gender is a social idea. Clear? So, when it comes to biological, obviously there is a difference between, male and female. But gender, this concept has come up because of some social connotations, because of some social ideas. We have included a different. We have included a different role that a woman or a man will have, or we have come out with certain limitations on what is correct behavior for men and women. These are the things that we have come. That is what is called as gender appropriate. Okay, gender appropriate. Like, in just the best example, nurse. है ना? जब हम कहते हैं nurse, we always conceive a female, but that is not the case. कौन कहता है female ही nurse बनेंगे? But we conceive it. ठीक है? When we talk about homemakers, women, अरे मैं भी चाहता हूँ homemaker बनूँ मैं. That is not conceived in that manner. ठीक है? Article 327. It confers the power on the parliament. It confers the power on the parliament to regulate elections. To both the houses of the parliament. And state legislatures, including the preparation of electoral rolls, delimitation of constituencies, and all other matters necessary for securing the constitution of both the houses of the parliament, the constitution of both the houses of the parliament and state legislatures. When I say constitution of the parliament here, it means formation, but formation will not be the appropriate word to be used because it is already in existence. So I have used the term constitution of the parliament. That means, underline here the parliament, in the confers the power to the parliament. Underline that, confers the power to the parliament to regulate elections. So in India, you will find that the laws that are made, that are enacted to regulate elections, they are being made by the parliament. We have talked about Representation of People's Act, that is an example of it. We have also talked about anti-defection law, who will be disqualified, etc., etc. So they are all regulating the mechanism of elections and representation in India. So that the authority to make such laws lies with the parliament. Next, Article 328. Article 328. It confers the power on the state legislatures to regulate elections by law to their respective state legislatures provided the parliament has not made any law in this regard or the law made by the parliament are insufficient to regulate elections in the state. Clear? So even the state legislature can make a law, but there are conditions on it. First, the parliament has not made a law. Second, if the parliament has made a law, the law is not sufficient to regulate elections. Only then the state legislature can make a law. Till now, there has not been any such law that has been made by any of the state legislatures, because Representation of People's Act is what regulates elections. This is Article 328 of the Constitution. There is one more article here, 329, and then we complete our discussion on organization of elections and we move to the constitutionally the last part of our discussion, that is the Election Commission. There is also a topic called as electoral reforms. But see, first of all, the topic is very old. Now the topic is very old. It is all, you might get it somewhere, if you are reading yojanas, etc., every 2 years or something like that, there is a yojana that comes up on electoral reforms. But if I get an opportunity, then I'll dedicate around an hour's time for this very idea, electoral reforms. Otherwise, you will get number of articles on it. Whenever the Prime Minister talks about simultaneous elections, so Hindu criticizes it, it will be mentioned. So all these things are there. Clear? Thank you.